The future of fair voting rights hangs in the balance as the Supreme Court prepares to make a decision that could fundamentally alter the landscape of American democracy. But here's where it gets controversial. On Wednesday, the conservative majority Supreme Court will tackle a case from Louisiana that challenges a cornerstone of the Voting Rights Act of 1965, a law designed to protect minority voters against racial discrimination. This isn't just about redrawing district lines. It's about whether states can or should consider race when creating those lines to ensure fair representation. And this is the part most people miss. The court's decision could either uphold the spirit of the 14th and 15th Amendments, which guarantee equal rights for all, or it could dismantle decades of progress in minority representation. The case revolves around Louisiana's congressional map, which was redrawn last year after a lawsuit demanded the creation of a second majority black district in a state where 1/3 of the population is black. The original map had only one such district, raising questions about equitable representation. The Supreme Court initially heard the case earlier this year on narrower legal grounds, but in an unusual move, expanded its scope in June to address a broader constitutional question. Does drawing districts to ensure majority black representation violate the Constitution's guarantees of equal protection and voting rights? Here's the crux of the controversy. Conservatives argue that the 14th and 15th Amendments prohibit any consideration of race, period. This aligns with the court's recent colorblind approach, exemplified by its 2023 ruling that ended race-based considerations in college admissions. Louisiana, which initially defended its redrawn map, has now switched sides, joining a group of self-identified non-African American voters who claim the map is unconstitutional. The Trump administration supports this stance. On the other side, civil rights groups are fiercely defending the map, arguing that ignoring race in redistricting would perpetuate historical disenfranchisement. The Voting Rights Act has long been a target of conservative challenges, with the Supreme Court weakening it in 2013 and 2021. However, in a surprising 2021 ruling, the court reaffirmed the need to consider race in redistricting to comply with the law, in a case from Alabama. That decision was a narrow 5-4, with Chief Justice John Roberts and Justice Brett Kavanaugh joining the liberal justices, though Kavanaugh expressed doubts about the long-term viability of this approach. A ruling in Louisiana's favor could drastically reduce the number of minority-majority districts, likely decreasing minority representation in Congress and state legislatures. This could have significant political implications, particularly for Democrats, as black voters tend to lean Democratic. A quick decision would allow states like Louisiana to redraw districts in time for the 2026 midterm elections, potentially shifting the balance of power. But here's the thought-provoking question. Is a colorblind approach to redistricting truly fair, or does it ignore the lingering effects of racial discrimination? Does the Constitution's promise of equality require us to consider race to achieve fairness, or does it demand we ignore it entirely? The Supreme Court's decision will shape not just the future of voting rights, but the very essence of equality in America. What do you think? Let's hear your thoughts in the comments.